So today we have with Honorable Mr. Justice Ananga Kumar Patnaik, who is the former judge of the Supreme Court of India. Sir was enrolled with the State Bar Council of Odisha in 1974. As an advocate, he's practiced in the High Court of Odisha in subordinate courts and tribunals in the state. He specializes in commercial and constitutional law. He was elevated as an additional judge of the High Court of Odisha in January 1994. Subsequently, in 1994, he was transferred to the Guwahati High Court, where he subsequently became a permanent judge in 1995. He became Chief Justice of the High Court of Chhattisgarh in March 2005. It's an absolute honor to have you here, sir. Please join us on the stage. Can we please have a huge round of applause? We also have with us Honorable Justice A K Sikri, that is Tarun Kumar Sikri, former Supreme Court Judge of India. He's an eminent jurist. He's an international judge at the Singapore International Commercial Court, Singapore Supreme Court, and is also the chairperson of the News Broadcasting Standards Authority. Further, he also acts as an arbitrator in domestic and international disputes. Sir, it's a pleasure to have you on board. Please join us on the stage. Can we have a huge round of applause for Honorable Justice A K Sikri? Thank you so much, sir. It's a delight to have you here. We'll also be joined by Honorable Justice Justice Waziri. Sir was also here for a session today in the morning, and obviously Mr. Siriji also referred to him as the Green Judge. You very well know, I think he's been introduced before, but two unique parks in the Indian capital of Delhi that is themed on the entombment and justice called Mafi Bagh and Saf Bagh were created as a result of the court orders that Justice Nazmi Waziri has given. And it directed the errant residents to plant trees as a sign of penance. I'm sure he'll join us and we'll have a wonderful time. And finally, we also have with us Mr. Tarun Nangia, who is a consultant at NewsX. He's the first media man to interview a sitting Supreme Court judge. He's also the editor at Legally Speaking TV show on NewsX. Sir, it's a pleasure to have you on board. Please join us on the dais. That's it. The panelists will take it from here. Thank you, guys.
Good afternoon. Good afternoon, all of you. It's a post-lunch session, so I'll try to make it as entertaining as possible. I know sitting through post-lunch sessions is quite a task, but I'll try to make light of it. I'm happy to be moderating a session with Justice Sikri and Justice Patnaik, and the topic is known to you, advocates who are judges' delight. If any advocate that I know would have a key to being a judge's delight, you know, he would feel that God has blessed him and he's the special one in this world. That's a task for any advocate to be a judge's delight. But we'll try to decode what that means from a person's point of view who have served on the bench and who have heard thousands and thousands of cases over the years. I'll go to my two panelists. And first of all, I would want to go back into their history of what was their experience as an advocate when they argued their initial cases before they went on the bench. And I would like to start with Justice Sikri. Your first few cases and what did you learn that time? How was those interactions?
Thank you, Tarun, and good afternoon to all of you. As rightly pointed out by Mr. Tarun Nangia, after lunch session, and that too after such a wonderful stage play, or I would call on Mahabharat, we have to ensure that this discussion is lively, not as monotonous as the arguments in the courts are, very dry and monotonous many times for judges who tend to sleep as well. So I think it should be more anecdotal, which I'll try at least as we progress. And coming to this question, Let me say that I was lucky that way in my initial years. Maybe for the reasons that I thought that whenever you have to go to the court, you have to be very well prepared and brief in the matter. And three things, if I may say so, in nutshell, which are required of an advocate, is that you are well prepared, which I said, you are courteous to the court when you argue, and be as precise as possible. Don't waste much time. This is the, I would say, lesson which was given to me by my senior. Within 1 month of my joining the profession, naturally for many months you remain with your senior, senior is arguing and you are just assisting him either in the court or in the chambers. So it was about 7:30 in the evening, and he said that, look, this writ petition is coming, it was in the High Court, this writ petition is coming in the High Court, you have to go and argue. So I was totally nervous. It's not a suit where notice will be given in any case, and you may not get interim injunction, ex parte injunction. In a writ petition, it can be dismissed in limine also on the very first day. So I still remember I kept on preparing that matter till 12:30 or 1 in the evening, was thinking that the judge may ask this question, that question, and I was preparing myself from all angles. So I had to be well prepared, which was the first lesson which was given to me. And when I reached the court, and I started, I could make out in 1 or 2 minutes that both the judges on the bench had read the brief very thoroughly. And, but they asked me a few questions, which I tried to reply, and I gave those replies. After 5 minutes, the senior judge says that, okay, we admit and stay granted. And he said, I know it may be your first appearance in the court as an arguing counsel, but we just wanted to test. We were convinced about this, but we wanted to test your knowledge, and we are happy you have prepared. That boosted my, I think in service, I was a lot of, I mean, there was an encouragement. Within 2 days, then my senior said that now tomorrow you go and argue this case. Also, it was the same bench. But that was very, very difficult case where it was, I think in a labor court, LPA was filed where we had lost before the labor court, we had lost before the single judge, and chances in the latest patent appeal were very dim. I initially hesitated and told my seniors, sir, you do it. I don't want to do it. There is a risk. What the client would say if ultimately such a case, if we lose the case, is that no problem, I'll take the responsibility, but you go and argue yourself. Luckily for me, in that case also, after struggling for 5 or 10 minutes, I could get a notice issued. But the main thing which I remember, and again, same bench, and I feel that that particular bench was quite, I mean, good to me in that sense. It was now another case, which was case for final arguments. And again an LPA. Of course, here in the writ petition, we had won and we were respondents. So the other side was arguing, the lawyer, a very, very accomplished lawyer and senior advocate on the other side. And I, on the respondent side, I was sitting along with my senior. And he argued for 1 day. Arguments went on because it was final arguments. Of course, I had also prepared along with my senior. Second day, again, he kept on arguing. And the third day, my senior had to go to Supreme Court for some admission matter. And he said that, look, the other side is arguing and he will take substantial time. And by that time, I'll come back. I said, okay. And that advocate was very sharp, very smart. He saw that senior is not there on this side because he had already argued for 2 days. Within 15 minutes, he packed his arguments. He finished his argument. He said that, my lord, whatever I have to say, I have argued. Now, in a final argument matter where one side has already argued, on the other side, you can't say that your lordship may pass it over, my senior has to come. So I started arguing. I had no other choice. And the good thing was, at about 12:30 or quarter to 1, my senior came rushing inside, and he wanted to take over. The judge on the bench, he just said this to you, wait, let him argue. And I still remember on that day, after lunch, there was full court meeting. And in those days, full court meetings used to be during court hours only. Now, I mean, we have the meetings only after 4 o'clock or after court. So the judges said at that time that, look, 1 o'clock when they were rising, that tomorrow they told my senior, you don't have to come at all, and let him argue. And again, these are some of the pleasant experiences which I have, I mean, in the beginning of my career. And maybe thing is, as a junior advocate, many times what happens, which I have seen as senior also, and which I have seen as judge also, that many times junior advocates, when they think that senior is to argue, they won't bother much. But I think one has to prepare as if you have to argue. What kind of emergency may come at the fag end? And judges are there to help you, which we have done, both of us have done as judges. When it came to junior bar, we would encourage them. So therefore, that is what I can say in nutshell is my experience.
Thank you for sharing that anecdote, and be prepared for your matter, even if you're not leading it, is what we learn. I recently had the pleasure to listen to Justice Patnaik's interview. This is what I was sharing with him before the panel started. And he has an art of storytelling, and so we would like to, in a sense, know about those few instances when you appeared before the bench, when you were practicing, and some anecdotes that you remember, some comment that somebody made, when you were encouraged. How were the judges then when you were arguing?
Hello. When I joined the bar, I was sitting in the back benches in the courtroom, particularly Chief Justice Court in the Orissa High Court. And I was full of confidence, very sure that I'll make a good advocate. And when I used to hear the arguments of the older members of the bar, senior advocates, I used to wonder why this man is arguing like this, foolish fellow. He could have put his arguments better. Right. I don't know how things were very bad when you stand before the judges. Then when the senior didn't come, I had to manage the show till the senior arrived. I got up, I started arguing. Then I realized how difficult it is to answer questions from the judges. As soon as the senior came, I just handed over to him. Sir, you continue. Gradually, the confidence developed. And how, let me tell you. I used to come very often to the Supreme Court as a junior young lawyer to assess seniors like Falil Nariman, like Mridul, P.R. Mridul, then like Kakkad, S.N. Kakkad, like Ashok Sen. And then I'll go with them to the Supreme Court and observe their performances. And gradually I thought the best way to handle the judges is to be fully prepared on all possible questions. Mr. P.R. Mridul used to write in a register full notes, what he will argue, what he will argue, what he will argue. And I copied his style when I went back. When I had discussion and conference with Mr. S.N. Kakkad, he will sit down and he'll pose all kind of questions. If this is the question from the judge, how will you answer? I'll answer it. If this is the question from the judge, how will you answer? So he was prepared, he was preparing at home in the time of conference. What are the likely questions which may arise from the bench, and they are difficult questions. How do we answer it? And he took the help of the young lawyer assisting him to find the answer. When I worked with Falinariman, he was pretty fast. No patience. Very bad in temperament. Come on, you say it. What is the answer? How do you argue this? How do you argue that? Right. Then I thought to prepare Mr. Falinariman to have a conference paper with Falinariman, one must read away a lot. Go fully prepared. So when I go fully prepared, and there was a local act, Odisha Act. When I was briefing him, suddenly he tells me, you must have read that act 100 times. I am reading it the first time. Why don't you understand? So all kinds of problems you face with the senior advocates. But the most skillful thing that a young lawyer, he should be able to handle all kinds of people. Maybe a bad senior, maybe a good senior, maybe a very bad judge, very rough judge, maybe a pleasant judge. So that adjustment has to be thought of. And as I grew, apart from preparations, full preparedness, in the case, which you can answer, you must also devise strategies. Strategies before each judge, at least the presiding judge, you must have a strategy. Let me tell you some instances. There was a central excise case which I had briefed a senior, Mr. Ranjit Mahathi, very senior man. And it was before a bench headed by Justice P K Mahathi and somebody. And Justice P K Mahathi did not know any central excise law. So early in the morning, Mr. Ranjit Mahathi telephones to me, I have read your brief, but we've got a very bad bench, he says. I said, why? He does not know anything of central excise. How do you make a point there? I said, sir, it's a very good bench. No, why do you say so? He's a master in civil law. And the only point we have is limitation. Heavy demand, central excise. But if you raise a point of limitation before Justice Mahanti, he will say it is barred by limitation, I can't help you. So our main contention is this demand of central excise is barred by limitation. He says, right. We went to the courtroom. In 5 minutes, the judge was with us. He granted stay. He told the excise department, you may have a demand of crores, but this is barred by limitation. Because that was the strategy that Mr. Mahathi played. He first pointed as barred by limitation. I'll give you a second example. Another central excise case was there. A heavy demand. The matter came before 2 judges very fond of chewing pan with little tobacco in it. And that tobacco, we used to call it dhulugundi. It's not normal tobacco. It's typically from Odisha. Dhuli gundi. Right. Then my junior comes to me. He says, this case will come up before this bench. What will they understand of central excise? I said, which is the bench? Justice so-and-so, Justice so-and-so. I said, very good bench. And why? They are very fond of pans and that to dhuli-gundi. Right. When I started arguing, he said, what is this case? The senior judge asked. Junior judge was always like that. He never opened his mouth. I said, this is a case of dhuli-gundi. Then senior judge, became like this. And the other judge, he just got up alert. What is the matter? 3 minutes, stay granted. And the central excise lawyer saying, what is this? I have not been heard. Then you come back after notice, we'll see. And then it all depends which judge is hearing. And which judge is fond of what, which judge hates what, which judge stiff. There was a great judge, our Chief Justice, Justice Ansaria. He came to Supreme Court also. Very fair judge. Very fair judge. He decided one matter. That matter got final in the Supreme Court. Then it was an eviction matter. So the law, the eviction order had passed ex parte. Ex parte order got set aside. In the meanwhile, he had been evicted. So Justice Ansaria said, this is the executing court, has to put him back. The ex parte order has been restitution. Right. Then, under the tenant, there was a subtenant. He came to me. How am I protected? I was not heard. I said, doesn't matter. Have you taken a stand that you are a subtenant? You make a move before the executing court. He said that, have it dismissed. He dismissed it because the Supreme Court has done it, the High Court has done it, I not. Then he came to me. I filed a petition by the subtenant. And the only ground I took was that I am a subtenant. I can't be evicted unless the tenant himself initiates proceedings. Tenant has got evicted. That apart, what this fellow has done it, he says that my argument that was before the court was, my ground, that subtenant has to be separately evicted by tenant. That is recognized. My junior said, how can you bring it? It has been listed before Ansaria. Same court, which has passed the order which is being executed. I said, very good court. Very good court. Why? Chief Justice order, first one. Which other court will interfere? I'll have to persuade the Chief Justice only. It came before Justice Ansaria. The moment it came up, he said, he never struck us that there was a subtenant on it. And he issued notice, and gradually he put us back, subtenant back. And so you file your remedies. Right. So this is what it is. These are the experiences. So the first is develop confidence gradually by preparation. Second is your strategize depending on the judges, which judge you are appearing for him. And then gradually you will find you are getting your orders. Thank you.
Thank you. Thank you for sharing those anecdotes. It was indeed enjoyable to listen to your anecdotes. Now we'll go to Justice Waziri, and our question was that what were your initial experiences arguing before judges? How did they indulge you? How were their moods? Any anecdote that you remember when you appeared in your initial days as a lawyer? Before, of course, you had a long career as a lawyer before being elevated. So if you could recount one or two instances and then we move ahead.
To be always prepared, not once but twice or 4 times over, to be fully sure of what your case was, both in facts and in the law, and to think of your arguments much in advance, to think of the various aspects of that, where the case could go, what questions come your way. But believe me, that no matter how well you're prepared, there'll be a googly from the court and you won't be really able to field it. I mean, that's always comes there. Be that as it may, I always went to the court with a positive attitude. That ye humko to yahan se, I'll get my relief. I went with it. And you exude confidence, you exude positiveness, it does carry. That's what I would do. If I didn't know the court, I would go and sit and watch. How does this court function? What is the style of this court? That's always there. As a young lawyer, one would just go and sit and watch the proceedings, hear the stalwarts of the bar, learn their style of arguments. And I think as one got along, you learn so much. I remember arguing before uh, Justice Sikri many a times, many times. I knew his kya pasand hai, inko kis tarah se, what kind of arguments he likes. Precise. And, you know, when judges are sitting, they really don't have time to waste. They are very precise about things. Padh ke aate hain, taiyar hote hain. And there are areas, small areas, where you have to just gradually persuade them. And think of them as seniors and friends and elders. That mind, that the judicial mind has to be persuaded. In the most polite language, I always believe in language. And the language which is enriched and steeped in beautiful words and expressions. Not necessarily poetic, but definitely a richer vocabulary helps in putting it across. No harshness, no speaking loudly. It's persuasive, polite voice that is what goes into the mind. If you're speaking too harshly, it never helps. And I remember so many a times appearing before sir. मुझे एक वाक़या याद आता है. And it was, sir, you'll recall, it was regarding the blue line buses that had to be removed from Delhi's roads just before the games, 2010. There was a stay going on for 7 years. चले जा रहा है. रोज़ वो, they would be killing people on the streets, poor accidents, etc. Now, how do I persuade this bench? Very good bench, but I had to show them the entire data, a lot of data, and these 2,100 people or whatever, something like that, they would be displaced. And उनके लिए तो it was like, हाय ये तो क़यामत आ गई हमारे लिए, हमारी buses हटा देंगे शहर से, हमारा क्या होगा? But if you break down the details, you found that it's only about 200 bus owners who were plying those 2,100 buses. And they were actually a menace on the streets of Delhi. The government wanted to introduce the low floor buses, which you find in Singapore and other places. So it was difficult when it's a state policy to replace private buses with public buses. It is that element which had to be put across to the court in the best way possible and to bring them there. And I recall possibly not even opening the file because one was so brimming with the facts of the case and the literature. Their lawyers started saying that, you know, what will happen to us? We'll be on the streets. I said, but you're killing people every day. Yes. When the child comes on the scooter with his father going to school, the child doesn't know and the father doesn't know whether they'll reach the school, the way they were plying the buses. And that was the moment for the court to seize and pass an order. Remember quoting Shakespeare there. There comes a tide in the affairs of men, which taken at the crest leads on to fortune. And many other things I had to speak about. We brought in Tennyson, we brought in Shakespeare, we brought in Raleigh. It's at that moment when you're at the crest of your argument, when it's going to persuade the court, that's where literature comes in. That's where the best of your preparation comes in. And I found sometimes it was a delight to argue before court, but I always went with a positive mind. And yes, we were blessed with the best judgments. Thank you, sir.
Thank you. Thank you for sharing that anecdote. Now we go on to our next question. When I was jotting down a few points for what I'm going to ask the eminent judges, I wrote down these things. There are many types of arguing styles. You hear about a lot of advocates and many are known for the kind of arguments that they do. First one is loud and aggressive. When I say this, you'll have some faces. This advocate is loud and aggressive. You all are smiling, so I think you guessed who is loud and aggressive. Then soft and persuasive. Soft-spoken advocates who try to persuade the judge. They're never loud in court. They try to put across a point succinctly. Then firm yet not loud. They are very firm, but they will never be loud. We are smiling and calm-faced advocates. They are always smiling in court. The case is against going them, they will be smiling. The case is going for them, they'll again be smiling. They're calm-faced. Can you share your experiences without taking names, that what style works on a miscellaneous day, cross-examination, final hearing? So, you know, because each kind of hearing would require a different kind of demeanor in an advocate also. Could you share your experiences? And then, of course, to the panel, the question is the same. Over to you.
Thank you. You have said two things. Number one, style works in the miscellaneous day, cross-examination, final argument. So different types of situations and then different styles. So which style works? And I tell you, it's not that one size fits all. It all depends on the circumstances, the nature of the case, and as you have rightly mentioned, whether it's a miscellaneous case on a miscellaneous day or it's a final arguments. So on a miscellaneous day, we know it is like T20. You have to, it's not even T20. Sometimes we have seen T5 also. In 5 overs, the game finishes. So in 1 or 2 minutes, you have to impress upon the court. And when it comes to final arguments, again, you may go on for even days together. So it may become 5-day test match as well. And some of the constitution bench cases have gone for 30 days, 40 days also in India particularly. What I feel when it comes to the arguing style, if you have seen, one thing which you have to learn from most of the accomplished senior advocates and many advocates which Justice Patnaik named when he had gone, all of them, without exception I would say, you would not find them aggressive or loud in the court. Not at all. They would be soft, persuasive, and even firm at the same time, but not loud. And I have seen another quality in these lawyers, all these top lawyers, I am talking of this beat, and most of them have now gone, with the exception of 1 or 2 who are left. They will not, even otherwise when the court is not with them, they will make their case, present their case in the best style which they can, and even if they get a order which is not favorable to them, and they feel, because they are stalwarts, they feel that the judge is passing a wrong order, they will still be respectful to the judge, to the court. That court may commit an error, that doesn't mean that we have to shout. At the same time, there are many lawyers who have developed very good techniques, being firm and not loud, but at the same time making their point. And I give you, again, you have said that I should not quote the names of either the lawyers or the judges, but let me tell you, one case, one senior lawyer was arguing in the Supreme Court, and SLP, the senior judge was saying, look, there's nothing in your, before even he started arguing, that there's nothing in your appeal, this SLP, and we are dismissing this appeal. Says, my lord, for one moment, please turn to page 32. See that page only, and I will not argue anything further. Said, no, sorry, there's nothing. He said, I beseech, please see page 32 again. Then judge again says, look, we have seen page 32, there's nothing in that. And you know, this was what he said. Okay, my lord, respectfully, can I ask what is at page 32? And what happened, he had not seen. And immediately he issues notice and grant stay. So sometimes with politeness, you say, put a question. And I again remember another, and these are all real things, I mean, these are not jokes, but real anecdotes. One matter was before, in those days it used to be, now we have a competition commission, but monopoly and restricted trade practices, MRTP commission. And the lawyer was arguing before the judge in the MRTP commission, and he said that, look, why you have come for this? It's a fit case for petition under Article 226, you should go to High Court. So go to High Court and file the case in the High Court. This is not meant for us. He says, no, my lord, your lordship may kindly see, there's a reason, a valid reason I have come. He said, no, sorry, go back to the, go to the High Court. He says, okay, again, turn to page 45. I don't want to say much, but turn to page 45. He says, what is there at page 45? Please, your lordship may kindly see. At page 45 is an order of the High Court that it is not a case under 226 and you should go to MRTP. And the order was passed by the same judge who was sitting in MRTP commission now. So now I tell you the courtesy of the lawyer. He would have said very bluntly in the open court, my lord, when I had filed this petition, you were only sitting there. And you had asked me that, no, sorry, not 226, go to the go to MRTP commission. But in a very subtle manner, he mentioned that, look, this is what, so the lawyers are can able to convey the same thing without being, and otherwise I've seen that, look, many times what happened, it's a tendency now, that many times we feel that if we shout more, if we are aggressive, we are able to cow down the opposing counsel, and therefore we will be able to win the day. That may not happen all the times. And there are ways I've seen in for the judges to convey that as well. Again, it was in the High Court, Delhi High Court. I was a lawyer at that time. Two very, very senior advocates were arguing, who were very, very close friends. And if may tell you, you have said not to tell the, this thing, I'm not telling the name, but I am giving clues which will make you easily understand who are the persons. One became law minister and other became attorney general. So they were arguing the case. They were senior advocates at that time and fighting against each other and shouting against, at each other in the court. The judge very politely said, he knew that they are very good, close friends. He says, why you are spoiling the mood and environment in this court? I know after, from the courtroom, when you go out, you will go to canteen, you will have coffee together. So I will not be able to join there. So please, but that make a little better environment here also. I mean, I know you are close friends, but just for the sake of this, you don't have to shout at each other. And then I think at least in that court, they never shouted thereafter. You see, I may also say that, look, many times, aggressiveness pays, not in other sense, but again, an anecdote I am saying. Here was a case where father in the profession was a very, very senior lawyer and very respected lawyer. It is not from Delhi High Court, from some other High Court I remember. And the son, who had also entered the profession and was there for 4 or 5 years in the profession. And in one case, lo and behold, on the one side, father, and the second side came to son. He said that, look, son said that to the clients, you want me to argue, you know, he's such a brilliant and senior advocate, is my father also, you have faith in me, that I should. They said, no, you please argue the case. Anyway, the case went on and it was decided in favor of father. In the evening, those very clients come again to that son lawyer and say that we want to engage you in another case. Said that in the morning only I have lost. Of course, the second case was not against father again, but that I have lost your case and you are coming to me again. Says, but we were impressed when your voice was louder than of your father. And we were very happy about that. So therefore, we know that we are in safe hands. But ultimately, what it depends is, again, I would say that courtesy always pays. And in the process, when a lawyer argues, he should be faithful insofar as the facts of the case are concerned, and one should not try to mislead. And because I tell you, reputation of advocates, to which category they belong, whether he is an advocate who unnecessarily shouts only without there being much merit in the case, or he is a person who tries to mislead. I have seen, and I'm telling you from my experience, and that would be of my 2 brothers as well, a particular gentleman, a particular advocate arguing, and when he or she is stating the facts, we won't even look into the file. We will take that at their face value because of their reputation. On the other hand, another advocate arguing, and then we have some doubts, we'll keep on turning the pages to verify what he or she is saying is right or wrong. And to tell you truthfully, we know advocates normally, they gossip about judges, which is so obvious. After doing the case, you go to canteen, you say, in this case, I had this experience with this judge and all that. Likewise, judges also discuss about the lawyers while having lunch together. So therefore, reputation either way, it travels fast. So therefore, and there are many, many occasions for a judge when discretionary relief is given. A case has come, and in that particularly injunction or stay, it is discretion to simply issue a notice, and we'll say that stay will be given, or we'll discuss about the stay only after notice and after hearing the other side, or one can give immediately thereafter. Here, the reputation of lawyer plays an important role for the judge to give such kind of relief. And so therefore, that honesty and demeanor in the court, that how you speak, etc., that plays a very, very important role according to me. And it is not that, as I repeat, that it is only aggression which plays. I have seen, if you should be firm. If one is firm and puts a case to, and up to a particular level, not that you have to keep on and on, even if the judge is not accepting, that you keep arguing the case or keep hammering the same point again and again, that will not help. Thank you.
Thank you. Thank you. That was such a wonderful answer. With so many anecdotes, really appreciate that. I'll go to Justice Patnaik for his round of anecdotes on the same question. The kind of advocates that he feels that and which personalities work on what kind of day. Over to you.
Well, let me tell you one thing. Ultimately, the advocate has to use his brains to persuade the judges to his line of argument. Right. And while on brains, I like to tell you a very good anecdote. Two friends, one was the public prosecutor and a huge, tall gentleman. And the other was the defense counsel before the session judge, very short gentleman, very witty. They were arguing before the court. When the public prosecutor was arguing, this little man was interrupting. And then he got angry. He said, Your Honor, if this little man interrupts me again, I'll put him in my pocket. And sharp came the reply, Your Honor, if he does that, he'll have more of brains in his pocket than his head. So ultimately, you have to use your brains to convince the judge to pass an order in your favor. That's the role of a lawyer, role of an advocate. Now, that may require very soft approach, very persuasive approach, very quiet approach. If the judge yields to that kind of a persuasion and happy with that kind of persuasion, please go ahead with it. But there are some judges who don't yield. They require a more aggressive style. Change your strategy before the judge. First speak quietly, and if you have a good point, very, very good point on merits, go, not aggressively, hammer it. Hammer it. It is not entering his head. One hammer to open up his brains. You never know. It all depends. He may have an ego, right? How that ego react. Sometimes you have to take a risk, but only when nothing is going to happen. Haar to rahe hain, right? I remember once a lawyer was arguing a matter before me in the Supreme Court. So I told him, look at CPC so-and-so provision. He looked at it, didn't respond. Made his voice louder. Right. Same arguments. I said, I told you, look at provision CPC. It stares at your, against you. Again, look at made his voice still louder. You know how I responded? I said, all right, dismissed. And the lawyer says, my lord, your lordship could have dismissed with a softer voice. I said, provided you had argued with a softer voice. But you are making it louder and louder. Right. Now, what Justice Sikri is right. No. So far as Supreme Court is concerned, don't take any chances.
No.
Last court, particularly on the SLPD or miscellaneous day. Be very soft. Last court. You can't afford to do that. And so far as High Court is concerned, it all depends which judge you are. Whether is a judge who is very well versed in law, very knowledgeable, or not sure of his confidence. This strategy you have to adopt. And I have adopted these strategies as a lawyer. Before some judges be allowed, some judges not allowed. And about the style, he said, don't mention any name. But I would like to mention some name to give an idea. What is this style about? So far as Venugopal is concerned, very persuasive. Soft and persuasive. So far as Nariman was concerned, Fali Nariman, hammering. Absolutely hammering. I may share one experience about Mr. Nariman, how it worked also. About the famous Lily Thomas case. When I was hearing, a judge was sitting with me, and it was that Representation of People Act challenge, whether an MLA or MP who is convicted, whether he should get disqualified and go out. So, each time the matter was taken up, first one judge said, I think this should be referred to larger bench. It was suggested to Mr. Nariman. You know, why will we refer to larger bench? Two judges can decide. Then I deferred the matter. I should have put in such counter by the Union government. Then he went, another judge came. She also said, sir, this should be referred to a larger bench. I thought it not wise to put this question to Mr. Nariman, because he had already answered. I said, why didn't you ask? She said so. And Mr. Falibanan said, if your lordships do that, I will think Supreme Court judges are shirking their responsibility to decide very important and controversial matters. Then I saw that. She was taken aback, judge concerned. Then I said, all right, we'll fix it on such and such date. We file a counter. Third judge came. First thing I asked him, would you like to, can we hear or should we left out? What is your view? Sir, if you take the view that we can hear it, we can hear it. Really? So how Mr. Nariman was getting his order? He stopped us from referring to large bench. They are techniques. These are techniques. There are no hard and fast rules. So it all depends what technique you follow, in what situation, apply. But don't be, as Justice Secretary, don't be discourteous.
Yes.
Don't misbehave. You don't use wrong words. Be very careful with your expressions. Very careful with your expressions. Don't do anything, don't say anything which will be contemptuous. So all these things you have to guard. A lawyer has to be very, very careful. Very, very careful. Don't open your mouth unnecessarily and utter any wrong words, which will create a lot of problem for you.
Thank you. Thank you.
Second thing, about the miscellaneous day. Miscellaneous day, you must know that all the Supreme Court judges, they read the brief and come. And on the brief at the top, there's a note page where we say what is the crucial point involved. Right. If a crucial point is totally favor of the petitioner, we don't also we issue notice straight away. And if we find on this crucial point we need an answer from the lawyer, we ask them, what do you have to say to this? This is our approach in the Supreme Court. So therefore, the lawyer who studies the brief must know what is the crucial point, where it will get stuck. This I should be able to answer before the judge. If he is prepared on that point, there is no difficulty. If he is not prepared on that point, khatam. If you don't answer that, no. Sometimes the senior lawyer knows that at this point we have no answer. So one senior lawyer got up. The judges said, Mr. So-and-so, you have no case at all. And he didn't know how to react. He said, when did I say I had a case? And the SLP was dismissed. So one should be very prepared. And then regarding cross-examination, I have worked in the trial courts also, both civil and criminal. The senior lawyer in criminal matters to whom I went, Mr. Boidar, in Odisha, you know how he will prepare his cross-examination? One day before the witness comes, he'll call me. He'll have an exercise book. He'll write down one question. If I put this question to the witness, how will he answer? I said, he will answer like this. Or he may answer like this. They said, then he'll score that off. Why take a chance? Why take a chance? But if either way answers, right, it may either benefit or not harm us. No problem. So this is how we is to prepare. In other words, prepare thoroughly well for cross-examination. What question you will put, what question you will not put. Right. Very, very important. If you put a question and he answers against you, you've had it.
Yeah.
Right. So, very, very, you have to be well prepared for everything. If you are well prepared for everything, it's very good. You succeed.
That is why it is said the best art of cross-examination is to know where to stop and stop asking the question.
Over to Justice Waziri for his set of anecdotes and his comments on the same issue. I'll just read the question again. See, there are many types of arguing styles. Loud and aggressive, soft and persuasive, firm yet not loud, smiling and calm-faced. Can you share your experiences without taking names on what style works for miscellaneous day, cross-examination, final arguments, etc.?
We've heard some of the best names in the field of advocacy, and one has really heard the finest ones, starting from, I've had occasion to see Mr. Palkiwala. I had occasion just to see him. I mean, that was a feeling in itself. Then we had Ashok Sen Saab, the biggest names, and then you had the style of, the inimitable style of Mr. Nariman. Amazing. His voice, the tenor and the tone, were a certain pitch, never offensive, persuasive, with a almost a, I won't say command, but yes, it was there. It was almost holding you in such rapt attention. Mr. Jethmalani. These were big names. People, I mean, Mr. Ashok Sen would speak so softly, and he had a way of persuading you. My own senior, Dr. Singhvi, L.M. Singhvi, these are big people who had their own style of persuading. Mr. Parasaran, Mr. Venugopal, Mr. Sibal, they all have their own style. But as a lawyer, one has to adapt to the occasion. And each one develops one's own style as you go along to speak. And you have to be nimble-footed for adopting a particular style on the occasion which is there before you. As Justice Patnaik said, मौका देखिए, उस हिसाब से अपना style बदल लीजिए थोड़ा सा. But as Justice Sikri said, it never pays to be rude. Verbiage in court, unnecessary expressions are not going to help. Facts and the law, that's also going to help. Courtesy pays a lot. Raising the pitch of the voice is not going to help. I've always believed that I am here to persuade the judge to that mind. That's a judicious mind, and his thinking. You have to bring him along, carry the person along with you. Bring the court here. ऊंची आवाज़ में कभी फर्क नहीं पड़ता. So I sometimes, in fact, quite often, senior seasoned lawyers will not speak unless it's occasion for them to speak. They'll keep quiet till it's time for them to speak up. The court is watching everything. There's an occasion I'll share with you. Abhi recent hai. After debating office, I had the privilege of appearing in the Supreme Court. I resumed practice, so I appeared there. And I was very conscious it was my first appearance. I made some opening statements, and the counsel on the other side kept on speaking, just wouldn't stop. I looked at the bench and I gently said, my lords, it appears that the rules here have changed, so has the custom. I believe the opposite counsel has to argue my case as well. So, उसके बाद वो खामोश हो गए, हमारी बात सुनी गई, and I got my relief which I wanted. It's a politely, humor is very important. Without being offensive, you have to put things across. Please appreciate the judges are overworked virtually. They have so much on their plate every day. So some bit of humor helps to lighten the atmosphere of the court. And I always appreciated that when there was some element of humor, some light banter at the bar and the bench, between the bar and the bench. चीखना नहीं है. एक वाकया अभी कहा गया कि कोई वकील साहब बहुत ज़ोर से बोल रहे थे. It doesn't help. I recall there was an execution matter, and in an arbitration, after an arbitration award, and I found there was nothing in the matter. So I just dictated the order in the court. There were four young lawyers, I still remember, and they kept on saying, Nini, I have a point, and he made all his points. I dictated the order. After it finished, there was a young girl. She kept standing there, her sheer consternation on her face as to what has happened. She kept looking at me. After some time, she went away. In the evening, when I had to correct the order, I read through it, and I went through a certain judgment. And I found that I was wrong. But there was a case made out there. So I went to a senior judge. I was a fresher. I went to a senior judge, and I said, sir, I seem to have made a mistake here. What should I do? He said, you can issue notice. So I could have issued notice. I had already told the court master to tell the other party, to tell them to come back. They had gone, so I said, okay, I'm going to put it up with the note below the order. At this stage, it is noticed that this case requires some more study, and I signed the second part of the order, and with the previous order, I uploaded it. So, गलती होती है. You have to, sometimes, खामोशी भी काम कर जाती है अदालत में. It's that consternation, look of consternation on the young lawyer's face that kept on haunting me. कि नहीं ये तो गलत हो गया. It happens. हमेशा ज़्यादा बोलने से फ़ायदा नहीं होता है. Thank you.
Thank you so much. Would have loved to ask many more questions. There are many more anecdotes, but I was told we are short of time. There is one question in the audience we take and we finish this panel.
First of all, I am grateful to listen to you. It's a pleasure. Appearing for the first time in my life before Honorable Supreme Court of India, I was heard for 5 minutes and the order was passed. After it was passed, then it was revealed that I am a party in person. The order was passed. Subsequently, after 1 year, when I appeared before same judges and order was in my favor, they actually, senior judge actually tried to backtrack upon the previous record, Article 129, and President Secretariat ultimately had to interfere through emails via law minister. So how to tackle such situation? This is only because that I was again appearing in person And in between also, I appeared in 4 to 5 or 6 cases in person. So that honorable judge was not liking that, and he was backtracking upon his own previous order. How to...
You have an interesting question, but it's a detailed one.
This is
I think
for in person.
Yeah, so we take it after the panel on the sidelines over coffee. I think...
Yeah,
because
I want tips from honorable
no, thank you.
retired judges.
Thank you.
Only last anecdote on that, what you said. One lawyer was arguing, he had come from district court and arguing in the high court before a very senior judge who went to Supreme Court also. And it was civil revision, where the scope is very, very limited. And before he could make his point, the judge said, sorry, there's nothing in it, and I'm dismissing it. He still tried to persuade. He said, no, there's nothing. And within 2 minutes, he dismissed the civil revision. And what you are saying, sometimes one has to deal like this also, and some humor as well. His client was also some rustic who was standing beside him, and he said in Punjabi, "Bauji ki hoya? What happened?" And his reply was in front of judge, "Judge साहब कह रहे ने मैनू समझ नहीं आया, एनू तुसी Supreme Court ले जाओ." So you should have gone to Supreme Court.
Thank you. Really appreciate you sharing that anecdote. I think Justice Waziri wants to speak and then we end.
You know, sometimes, like I was talking about banter in court. There was a matter before me, I think in the criminal side or something. It's a young lawyer, never seen him before. The case was Ram Prasad Bismil versus State. So the name was so amazing. I said, now I'm going to have good time in court about some literature, some poetry, things like that, something about. तो वकील साहब से हमने कहा कि did you राम प्रसाद बिस्मिल को represent करते? हाँ sir, client. I said, all right, tell me about him. Started telling about the case. So anyway, he had a case, so I dictated the order. I gave the relief. I said, but the relief will not be signed. The order will not be signed till you come back and recite something about Ram Prasad Bismil. Go and learn about him. Mercifully, that young man somehow said in his own style, "Sarfaroshi ki tamanna ab hai hamare dil mein." तो वहीं दस्तखत हो गया था.
Gentlemen, a big round of applause. They've shared a lot of anecdotes.
I think this.
They say that clapping is good for the heart, so for all your long life.
I think this session deserves a standing ovation. If you could please just all. You know, anecdotes are like currency of conversation. We are all going back very rich today. Thank you so much for those anecdotes you shared, sir. I would request Shri sir to come and present us. All the guests with the mementos. Thank you.